Now we're going to talk about the decision you receive from the judge related to money. We find out if you're a winning party or a losing party. This is called the judgment, how to understand it and how to react to it. You'll receive your judgment within 10 to 12 days after your court hearing. And you'll know this because the judge will say, I am taking the case under submission. Your decision will come on a form called Notice of Entry of Judgment. This is an important form that will start the clock ticking for any further action. You must ask the judge for money to get in the door. But in addition to money, you can ask the judge for something different, and the judge can award you something other than money. For example, let's say you have a neighbor with a very big tree with long branches overhanging your property. You want them to remove those branches. The judge can order the defendant to pay you the cost to remove the branches on the condition that your defendant doesn't remove it himself by next week. The judge will maintain control of your matter until the next hearing. If defendant in fact removed the branches, great. There will be no judgment against his credit record and you are happy. If he did not, or if she did not, then you will receive your money. Now, another common occurrence that occurs in small claims is that the other party does not show up. If you are a plaintiff and your defendant does not show up, you just need to show the judge that you gave proper notice. If you did personal or substitute service, this means that your proof of service is filed. If you did service by certified mail, this means that your return receipt is signed. Then you can go before the judge and tell them your one-sided story and likely get a default judgment in your favor. Same thing for the defendant. So plaintiffs, if you can't go to court, you want to make sure you let the clerk's office know that you're not going to be able to make it so they can postpone your hearing. Otherwise, the defendant can go before the judge and tell them their side of the story and either get your claim dismissed or get their own claim heard and get a default judgment against you. If this occurs, it's not the end of the world. Plaintiffs, you have a right to erase the decision that is made, called the default judgment. And you will do this by vacating the judgment. There's a form that you can fill out at the clerk's office. You must do so within 30 days of the decision. You'll have a new hearing where you'll have a second chance to tell the judge why you were not at the first hearing. Likely the judge will want you to have your day in court, so be prepared on that day to present your case for the first time. Same thing for the defendant. So plaintiffs, if the defendant does not show up to the first hearing, remember they have 30 days to vacate or erase the decision. And be ready on that day to refute whatever they're going to say. Now, what if you lose? The first question that's going to pop to your head is, can I appeal? We all know that word called appeal. Well, it depends. If you lose on your own claim, you cannot appeal. But if you lose on the other party's claim, you can appeal. So that means if you're a plaintiff, the defendant has the right to appeal. And if you're a plaintiff, you only have the right to appeal if the defendant brings a claim against you. What is the small claims appeal like? It's a whole new hearing, and it's before a superior court judge. In fact, attorneys can represent the parties. But if you felt comfortable representing yourself the first time, you should feel confident representing yourself the second time, because it's the same informal rules as small claims court. Also, the original claims are the only ones that can be heard for the original amount. And you are allowed to ask the judge for any attorney fees or expenses related to the appeal. And no party is allowed to appeal for any purpose of delay or harassment. Otherwise, they can be penalized. And the decision at this level is final and no longer appealable. Now we're going to talk to all the winning parties, how to collect your money, and to the losing parties, how to satisfy the judgment. If you are a winning party and you receive the decision in the mail on the notice of entry of judgment, you are going to wait 30 days because the other side, the losing party, has 30 days to either pay you money or pay the court money, ask the court to pay installments, or file an appeal, or file a motion to vacate because they weren't at the first hearing. If defendant or the losing party cannot pay, then you must fill out the form on the other side of the notice of entry of judgment called Judgment Debtor's Statement of Assets, where you tell the winning party what your assets are. But many times, the losing party does not pay you. They do not appeal. They do not vacate, and they do not fill out that form and let you know what their assets are. So if you've waited more than 30 days, what are you going to do? You can ask for an order to produce statement of assets and to appear for examination. This is a form that can be found at your clerk's office. An examination or judgment debtor's hearing is where you will go to the courthouse and it'll just be you, the judge, and the losing side. The judge will ask both of you to step outside, and this is your opportunity to ask them questions about their assets. What car do they own? What's their bank account? Do they own a house? And if they're not answering these questions, you can tell the bailiff and they will be compelled to answer and go before the judge. The most the judge can do is order them to empty their pockets. Once you find out what the assets are of the losing party, you want to look at this slide and figure out what is the best legal action for me to take to get my money. The most efficient thing and quickest thing to do is a wage garnishment if the other party, the losing party, is employed. Once you're paid in full, you want to let the court know that you were in fact paid in full by filling out a form called Acknowledgement of Satisfaction of Judgment. This will be sent to you with your judgment. This is kind of like a receipt needed to end the case. And if you did fill out a court waiver and you won and got court costs awarded to you, you want to reimburse the court with these costs. These are all the potential costs that you could be paying for, depending on your claim. You'll likely be paying one of the 4 top costs just to begin your claim, maybe the other cost depending on your situation. Finally, before you go to court, you want to ask yourself, is small claims court my best option? To answer this question, you want to ask yourself 4 smaller questions. First, what do you want? Do you want money? Do you want an order? Or do you simply want an apology? If you want money, you're on the right path. Next question is, do you have a legal claim? Maybe you think you're right, but does the law think you're right? Does the law support you? To find out, you might have to talk to an attorney or do a little bit of research. This also means that your statute of limitations has not run out, that you still have time to bring your claim. Next, you want to ask yourself, is your claim less than or equal to $7,500 or $5,000 if you're a business? If it's not, are you willing to reduce your claim? But remember, if you do, you'll never be able to ask for that balance in any other court. And finally, you want to ask yourself, are you ready to risk it all? What are the risks? Well, one risk is that you file your claim and you lose, and you can never file again. Another risk is you file your claim, you win, but the defendant appeals, and then you lose. Or you file your claim, you win, maybe you win again, small claims appeal, but you can't collect. These are real risks, and many people take them, and they contain a small claims court, and they're successful. However, other people choose other ways to solve their dispute, such as mediation. So what's the bottom line? If you are thinking about filing a lawsuit, you're a potential plaintiff, you want to ask yourself, is small claims court my best option? Consider informal, less risky alternatives, such as settling the dispute yourself or using mediation. If you're already a plaintiff, remember to assess your risk before going to court. It's never too late to resolve your dispute yourself or with mediation, sometimes on the day of court. However, remember, if you do win, it's up to you to collect the money. The judge and the court will not pay you. Finally, if you're a defendant, remember again, it's never too late to resolve your dispute yourself or with mediation. If you lose, the judgment will be on your credit record, and it will grow at 10% interest. However, you can always appeal and have a fresh start in a new hearing. Now we're at the end of the presentation. Thank you very much for your time. If you need more advice, feel free to talk to an attorney.